First issue I will raise, because I think it's a fundamental precondition to the beginning, to the continuing to the beginning of this hearing. I assume that you, Mr. Bemba, and that you, Mr. Kilolo, you speak and fully understand French. I would ask you if this is the case. Mr. Bemba, please.
Oui, Monsieur le Président, je vous le confirme.
Mr. Bemba, yes, I can confirm that, Your Honor.
Thank you very much. Monsieur Kilolo?
Oui, Monsieur le Président.
Mr. Kilolo, yes, I speak both languages, but I'm more at ease in French. Thank you.
Thank you very much. Mr. Babala, what about you?
Mr. Babala, Your Honor, as far as I'm concerned, I would prefer French to be used.
Thank you very much.
Merci.
So, this settled, we can continue, and I would turn to the prosecutor to ask her to introduce the team of the prosecution.
Mr. President, Your Honor, the Office of the Prosecutor is today represented by Fabricio Waribia, the Senior Prosecutions Coordinator, Kweku Fandapuri, Senior Trial Lawyer, Florence Dark Lane, Trial Lawyer, Sylvie Vindina, Case Manager, and I am Fatou Bensouda, Prosecutor.
Thank you very much, Ms. Bensouda, Ms. Prosecutor. Now I would turn to the defense of Mr. Bemba to introduce herself for the record.
Ms. Biral, thank you, Your Honor. I am Gali Piral from Belgium, and I am a member of the Bar of Verviers.
Thank you very much. The defense of Mr. Kilolo.
Merci, Monsieur le Président.
Mr. Kilenda, thank you, Your Honor. On behalf of Mr. Kilolo, I wish to say that I am a member of the Brussels Bar, and I am ensuring the defense and interests of Mr. Kilolo.
Bonjour, Monsieur le Président.
Mr. Keita, good afternoon. I'm Xavier Jean Keita, Chief Counsel, Public Office for Defense Counsel, and at Mr. Kilolo's request, I'm attending this hearing on an exceptional basis. Thank you.
Thank you very much. Now the defense of Mr. Babala.
Monsieur le Président,
Mr. Dubanga, I am Paul Dunga and a member of the Bar.
Thank you very much.
Crescent Paris Bar.
Okay, thank you. The registry.
Mr. Dubuisson. Thank you, Your Honor. Here, representing the registry, is Ms. Beresara, who is a legal officer and coordinator, and myself, Marc Dubuisson, Director of Court Services and representing the Mr. Von Hebel, the registrar.
Thank you very much, Mr. Dubuisson. I myself, I'm Judge Kuno Tarfuser. I'm a member of PTC2, and the PTC2 has appointed me. When I talk about PTC2, I talk about Judge Trendafilova, Katerina Trendafilova, and Judge Hans-Peter Kaul, together with me. I was appointed as single judge to act on behalf of the chamber. My team is represented by legal officer Federica Gioia and by the intern Giulia Landi. So, before going on, I will want just to remind everybody to speak slowly because of the interpretation. We need a correct interpretation, so it's better to slow down. The object and the purpose of this hearing, of this first appearance hearing, pursuant to Article 61 and Rule 121.1 of the Rome Statute and of the Rules of Procedure and Evidence, is, first of all, to identify correctly the persons which are here detained as accused, then to determine whether they have been informed of the crimes which they are alleged to have committed. Third, to determine whether the persons have been informed of their rights. And finally, to set a date for the confirmation of charges. Therefore, now I pass to the first point, meaning the identification of the suspects. And I would ask Mr. Bemba, Mr. Kilolo, and Mr. Babala in this order to completely identify themselves with the name, place, and date of birth, and nationality, and any other thing they reckon is useful for their identification. Please, Mr. Bemba.
Mr. Bemba. My name is Jean-Pierre Bemba Gombo. I was born on the 4th of November 1962, and I'm from the DRC, from the Congo.
Thank you very much, Mr. Bemba. Mr. Kilolo.
Mr. Kilolo. Thank you, Your Honor. My name is Kilolo Musamba Aimé. I was born in Kinshasa on the 1st of January, 1972, and I am a Belgian citizen and not Congolese, as was incorrectly mentioned in the warrant of arrest, and I am a lawyer by profession. Thank you.
We will take care of this mistake we made in the warrant of arrest. Now, Mr. Babala, please.
Mr. Babala. Microphone, please. I am Fidèle Babala Wandu. I was born on the 27th of July, 1956, and I am a Congolese citizen and a member, or rather a citizen of the DRC and also a member of Parliament.
Of the DRC, yeah. Thank you very much, Mr. Babala. Now I come to the determination whether the persons have been informed of the charges. And I ask, first of all, the court officer to read out the charges in English and in French, as English is the original language, because the judge was addressed in English, so the first draft of the charges was, of the counts, was done in English, and it was the judge, the office of the judge, who has translated it in French. But I think if we read them in both, both languages, it is better. So please, court officer, you have the floor.
Thank you, Mr. President. For Mr. Jean-Pierre Bemba Gombo, count 1, presenting evidence that the party knows is false or forged under Article 71B, read with Article 25(3)B, by ordering, soliciting, or inducing his associates to present such evidence. Count 2, corruptly influencing witnesses under Article 71C, read with Article 25(3)B, by ordering, soliciting, or inducing his associates to pay money to and coach witnesses. Chef 1.
Count 1. Presenting evidence that the party knows is false or forged under Article 71B, read with Article 25(3)B, by ordering, soliciting or inducing his associates to present such evidence. Count 2. Corruptly influencing witnesses under Article 71C of the statute, read in conjunction with Article 25(3)b, by ordering, soliciting, or inducing his associates to pay money to and coach witnesses.
Et à leur donner des instructions. For Mr. Aimé Kilolo Musamba, count 1, presenting evidence that the party knows is false or forged under Article 71b, read with Article 25(3)a, by knowingly presenting forged and false documents to the court during the trial proceedings in the main case. Count 2, corruptly influencing witnesses under Article 71c, read with Article 25(3)a, by bribing and coaching witnesses to provide false testimony in court in the main case. Chef 1.
Count 1. Presenting evidence that the party knows is false or forged under Article 71b, read with Article 25(3)a, by knowingly presenting forged and false documents to the court during the trial proceedings in the main case. Count 2. Corruptly influencing witnesses under Article 71c, read with Article 25(3)a, by bribing and coaching witnesses to provide false testimony in court in the main case.
For Mr. Fidèle Babala Wandu, count 1, corruptly influencing witnesses under Article 71c, read with Article 25(3)a, by bribing witnesses to provide false testimony in the main case. Count 2, presenting evidence that the party knows is false or forged under Article 71b, read with Article 25(3)c, by aiding, abetting, or otherwise assisting in the crime of presenting evidence that he knows is false or forged. Chef 1.
Count 1. Corruptly influencing witnesses under Article 71c, read with Article 25(3)a, by bribing witnesses to provide false testimony in the main case. Count 2. Presenting evidence that the party knows is false or forged under Article 71b, read with Article 25(3)c, by aiding, abetting, or otherwise assisting in the crime of presenting evidence that he knows is false or forged.
Thank you, Mr. President.
Thank you, courtroom officer. Maybe when you've heard that the courtroom officer referred to the case or to the main case, obviously the main case is the case, the prosecutor against Jean-Pierre Bemba. But because it was not defined better in the, also in the counts provided by the prosecutor, led the judge to formulate some criticism in paragraph 11 of the warrant in French and in English. Just this for clarification. The single judge notes that the warrant of arrest has been served upon the persons upon their arrest, and that each of them is assisted by duty counsels, as we heard in the beginning of this hearing, appointed by the registrar. The single judge notes also that the three persons are not yet in the possession of the documents underlying the arrest warrant. And I refer in particular to the prosecutor's application for warrant of arrest and all its annexes. That these
during the testimony of the last witness, but I believe the prosecutor is well aware of that, and we had an opportunity to challenge those documents and show the veracity of those documents. I do understand what this is all about, and we will do the same work and provide the necessary evidence to show that, as far as I'm concerned, I have been acting in good faith regarding these documents. I believe I know what this is all about. So I can assure you, Your Honor, I have understood. I think it's unfortunate that this matter has gotten to this particular stage. I thought that these issues could have been dealt with at trial. Regarding corruption, that is a very strong word to my mind, but I do think that this is the opportunity to indicate that I differ regarding this word, which is far too strong a word. I am entirely willing to cooperate with the court, and I will do all I can to ensure that the truth is heard. I thank you.
Thank you, Mr. Bemba. I turn now to Mr. Kilolo to ask for his comments, if he has understood the charge, the accused, and if he has to make any comments on them. The floor is yours.
Je vous remercie.
Mr. Kilolo, thank you, Your Honor. I certainly have understood the charges, and I can assure you I do understand what the purpose of today's hearing is, particularly read in light of Article 71B. Allow me to state very briefly that I await with great calm the so-called evidence from the prosecution, so that I will be in a position to respond thereto in a very detailed manner with the assistance of my legal counsel. I do wish to say that as soon as notification of the warrant of arrest occurred, and as soon as the charges were notified, as currently defined, I immediately said to the Belgian investigating judge, Juge en Chaux, that I did not intend to take advantage of various proceedings that were possible to me under Belgian law, and that I wished to make myself available to the court and to the prosecution immediately to help with the demonstration of the truth. Consequently, whereas I was deprived of my liberty on Saturday, and I asked the Belgian judge to make all the necessary arrangements for my transfer to the seat of the court. So you see, my first obligation, because I must point out that I am the co-lead counsel of Mr. Bemba in the case against Mr. Bemba, and I do wish to state that I said to the Belgian judge, in the presence of investigators and members of the OTP who were there in Brussels at the time, I said that as a counsel before the ICC, it was my duty to make myself available to the court and to cooperate with the investigation and the proceedings. Finally, Your Honor, and I will conclude on this particular note, I was surprised to be deprived of my freedom, given that I spend most of my time in The Hague, within the very premises of the court where I have my offices. I do think that the prosecutor could have considered a prior hearing. I think Ms. Bensouda does not doubt for a moment that if she had called upon me in advance, I would have responded, I would have attended. And I do deplore the way, the strong-arm tactics, the humiliating way in which use was made of an arrest warrant. A mere summons to appear would have sufficed. I would have appeared. I don't think anyone doubts that point. So I do think it is really a pity that I was coming out of a meeting relating to an investigation that was underway, an investigation mission that was going to allow me to identify a number of criminal law experts who were actual specialists in handwriting and specialists in radio transmissions who were on duty when operational messages were sent by the Bangui headquarters, because that was the issue at stake when we were talking about forged documents. And I can reassure you, Your Honor, that I do think it is a shame that the prosecution made use of these tactics and also in this way harmed the work being done, the defense of Mr. Bemba in the main case, which has practically come to an end. We were already beginning to draft final submissions. As for the rest, I shall call upon my lawyers to represent me.
I didn't interrupt you because I understand your emotional moment. I can understand it, but if we keep it with the evidence and not the so-called evidence, because I mean there is not only involved the prosecutor, but also the judge had to make a findings on what you are calling so-called evidence. We know that you made yourself available to the court, and we are very grateful that you are here. And I think the prosecution is very happy if you are willing to help to demonstrate the truth, whatever the truth is, that we will find out in the very next future. About the summons to appear or not summons to appear, or the way this proceeding was triggered, also this is a decision which is not only a prosecutor's decision but also a judicial decision. Therefore, I don't want to defend the prosecution, but I just, as you perfectly know, this is the procedure. Now I turn to Mr. Babala for the same reason, asking if you have understood what you're accused of, and to make comments brief, as brief as possible.
Merci, Monsieur le Président. Mr. Fidèle Babala Wandu. Thank you, Mr. President. I am very surprised to find myself in this situation. Given the circumstances of my arrest, I did not have the time to really familiarize myself prior to the arrest of the charges. After my arrival here, I have had the time to read the documents, but I really do not understand very much. I will be very happy to have the underlying documents for those charges, but I like to underscore the fact that the circumstances of my arrest are not consistent with the relevant provisions of the Rome Statute. I am attached to my country, but I deplore the circumstances of my arrest. At 2 a.m. in the morning, with 30 policemen, my house was broken into, and my children traumatized. So I'm really wondering whether this is in compliance with the applicable procedures. That is what I have to say for the time being. Thank you.
Thank you, Mr. Babala. About the first thing you raised, that you have not very much understood. I am sure that your lawyers will explain better to you what it is about. And as you've heard just before, I reclassified for the defense teams all the documents on which the arrest warrant is based. So you will, in the next few days, understand better and familiarize with the accused. As your arrest, as far as your arrest is concerned, I think this is your concern. You have to raise your concern with the authorities of your state. We have just made a request of cooperation, but we can't influence the way the cooperation is done. So this is something which is out of our possibility to influence. So that's what I have to say. Thank you very much. And I will now pass to determine, the next step is to determine whether you have been all informed of your rights. On what I have read through filings which were done by the registry in the last days, I have been informed that you are that you have been informed of your rights, but to make it sure, I will read them out again. So just not to leave out anything. First of all, you will be presumed innocent until proven guilty beyond reasonable doubt at a trial, if we arrive to a trial, and the burden of proof lays by the prosecutor. You have the right not to have imposed on you any reversal of the burden of proof or any onus of rebuttal. You have the right to receive and to have disclosed to you material which shows or tends to show your innocence, mitigates your guilt, or which may affect the credibility of prosecution evidence in possession of the prosecutor. You have the right to object to the charges, to challenge the evidence presented by the prosecutor, and to present evidence yourself. There will be no trial in case the charges are not confirmed. And this is the proceeding we are beginning now. You will be informed promptly and in detail of the nature of the cause and the content of the charges, much more that you have been now through the arrest warrant, in the language which you fully understand and speak, which you told me altogether is French. You are entitled to waive your right to attend status conferences convened for the purposes of disclosure of evidence, which are more technical hearings. You will have adequate time and facilities for the preparation of your defense. You will be, for sure, tried with undue delay. You may make unsworn oral or written statements in your defense. You also have the right to apply for interim release, and you have the right to appeal decisions pursuant to Article 82 of the statute. I will now turn to the date of the confirmation hearing. The single judge notes that Rule 121 of the Rules of Procedure and Evidence makes it mandatory to the Chamber to set at this point the date of the confirmation of charges. It notes also that Rule 165.3 allows for the confirmation of charges relating to offences against the administration of the court of justice to take place on the basis of written submissions without a public hearing. It is the view of the Chamber, and I consulted on this issue with my two colleagues, of course, that this, and I mean by this, the written confirmation, is the most appropriate course of action in this case. This said, and obviously subject to changes which may become necessary in light of developments relating to the surrender of other two persons for whom the warrant of arrest was issued, the single judge, on behalf of the Chamber, sets the date of 18th of March 2014 for the filing of the document containing the charges and the list of evidence by the prosecutor. Following this date, of course, according to the statute, 30 days later, which means on the 18th April, both the prosecutor and the defense shall file their written submissions. The prosecutor shall then have until the 25th April 2014 to reply to the written submissions of the defense, and finally, the defense shall have until 2nd of May 2014 to reply to the submissions of the prosecutor. As you may see, when I said before that one of the rights is that you will be tried with undue delay, I think this is something which goes in this direction. As regards the disclosure of the relevant evidence, I hereby convene a status conference to be held on Wednesday, 4th December at 14 hours to discuss issues related thereto. I mean, to the disclosure. At this status conference, the prosecutor is required to indicate the status, somehow the status of the ongoing investigations. I mean, not the status in the content, but in the timing, and to provide an estimate of the amount and the nature of documents he intends to rely on for the purpose of the confirmation, including, in particular, whether she wishes to use witness statements and whether any redaction to the evidence will be required. The prosecutor is also required to indicate whether she intends to rely on documents or information provided under conditions of confidentiality. But I think lots of these does not apply in this case. The defense is invited to give to the Chamber, and to the extent possible, obviously at this stage, at this early stage, analogous information as those requested to the prosecutor. And the registry shall also attend this status conference and provide relevant information as to all the technicalities of the disclosure process. Before we come to the end, and I give the floor to both for comments or requests, I also ask the registrar, with the end of this hearing, to lift all detention restrictions related to communications among the three persons. So, as far as the initial appearance is concerned, I think I have completed. But before closing, I ask the parties and participants if they have any comment or concern or question to raise. The floor is to the prosecution.
Thank you, Mr. President. I will invite, with your permission, prosecution's coordinator.
Of course.
Good afternoon, Your Honors. Well, I start with one point in relation to the lifting of restrictions. We filed shortly before walking into this courtroom a request to maintain for a limited period of time the restrictions on communication between the accused persons amongst themselves. We filed inter partes, so the defense has an opportunity to respond to that submission, and only for a confined period of time in order to enable us to conduct the pending interviews of the accused, or the suspect at this stage. So I just wanted to flag that issue for Your Honor's attention. In relation to the date of the hearing, we take note of that, and we will make our best effort to make sure that we arrive prepared to that date. I only note that it's not only an issue of the pending surrender of the other persons including the warrant of arrest to this court, but it's also an issue of the transmission of the seized material to the office of the prosecutor. By this I mean both the material that is currently in the possession of the registry and the material that is still in the possession of the national authorities, and that will most likely be subject to a scrutiny to ensure that the office does not receive any privileged material erroneously. Now, this is a process that the Office of the Prosecutor does not control and may affect, undoubtedly, our ability to fully complete the investigation before the confirmation process. So I'm just flagging this issue in order to ensure that Your Honor is aware of this factor, and that this factor may have an impact on the date of the hearing. And that's all I have to say. Thank you so much.
Oh, sorry, I was already responding. Please, to the defense. The defense of Mr. Bemba, please. You have the floor.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. At the present time, I have no observations to make. That was Madame Pira.
Thank you. The defense of Mr. Kilolo.
Merci, Monsieur.
Mr. Keita. Thank you, Mr. President. Mr. Kilolo's defense would like to first of all thank you for the respectful conduct of this hearing. We thank all the parties. Also, the defense has taken due note of the dates that you have stipulated, and we will do everything possible to comply with those dates and not cause any delay. And we hope that the chamber will comply with the decision taken itself, particularly regarding the lifting of detention restrictions. This is neither the place nor the time, but the defense will write to the chamber, as is done in an adversarial process, and will raise questions about the timing of this case, raise issues about the consequences on the main case, and also talk about the involvement of the OTP, because the OTP is a full-fledged party to the main case also. Thank you. Mr. Kilenda. Thank you, Mr. President. There are two of us here, but I would like to join my voice to that of Maitre Keita. You have defined the purpose of this hearing, and under Article 61 of the statute, I would like to say the following. You have listened to the statement made by my client. He was fully occupied in his activities as a lawyer when he was shamefully accosted at the airport last Saturday. if the office of the prosecutor had taken the time to interview him, I do not think that an arrest warrant would have been issued against him. I know Mr. Kilolo for a long time now, and he has a well-known firm, a well-known and reputable firm in Belgium, so he could not have fled from justice. In fact, it was after the advice that I gave him that he accepted to make himself immediately available to the court so that the truth should come out. It is amongst these concerns, Mr. President, that I would like to know